bud. You ain't arresting me, bud. No, you're not.
He's 21. He's running.
Oh,
get over on your stomach. Get over on your stomach. Get over on your stomach.
I'm tired. What the is this for? What the is this for, man?
January 6th, 2024, Ross County, Ohio. A man living at his father's house, months past his welcome, is using the old man's cell phone to threaten a protected domestic violence victim. Officers show up, he runs. A taser gets deployed. So here's the question. At what point does running from a cop legally justify intermediate force?
Alright.
35.
Good.
Make sure we are going to bring this RC.
Right, we 21 them on their charges for TPO, right?
One of the probes wasn't on the thing. I think one connected. The other I don't think went in.
Are you? What's your guys' relation?
That's my dad. I came in to check on him.
Okay. Is he inside?
Yeah, he's sitting right there.
Okay.
My sister called and said that he was in here acting up, and I called in here and he was.
Who's that TPO against or for? Hello.
My sister, her husband, and his daughter.
Anyone here? Is it against him or for him at all?
No.
Is everything okay?
What happened was he was arrested and he went through court and everything, and he was only supposed to be here for a couple weeks, and it's turned into months. He won't get out. He needs mental help. He needs help so bad. Someone needs to force him because he's going to end up hurting someone or hurting himself.
Well, apparently the county has charges against him for protection order violation. That's why we
Because he's
also to check here.
He's using my dad's cell phone to text and call my sister and my nephew and threatening them.
Yeah.
She's got it on the phone and stuff.
Okay.
He just won't stop.
He took off running from us.
I seen it. We pulled up.
So he'll probably have charges from us too, from running.
The thing is, like I said, they arrest him, they keep him a day or two, and then he's right back out.
Right. That's our complaint too. We don't want to take him there.
And that's what he knows. He knows he's not going to get nothing out of it. You know, a slap on the hand.
Sometimes the court doesn't work in the victim's favor, but that's for them to decide.
Yeah. So, okay, when he gets...
Is everything okay here though?
Yeah, he's fine.
What was going on here?
I started creating myself on no more.
You told him that he couldn't use your phone?
No more. I thought
Hang on, buddy. I'm having trouble hearing you over the TV.
turn TV down.
I am not bad.
Alright. You said you wouldn't let him use your phone anymore?
Yeah. I told him he wasn't using my phone, calling threatening people, he's going to get them.
And then he started yelling. I was on the phone with Dad at the time, and he started yelling at him. Calling him, at the top of his lungs, cussing at him, calling him an old man, saying, come on.
Did he threaten you at all?
I put knocking on his ass, and he said, come on, old man, come on, old man.
You threatened to knock him on his ass?
Yeah.
Okay.
Here's the deal. So when he gets out, his stuff's here.
Mm-hmm.
What do we do to get him to stay away?
Monday morning, I would go to the courthouse, try to file for a protection order. That'd be your quickest bet.
Okay.
That way, they can force him out of the house, and if he comes back, he could be charged with protection order violation, just like he is for calling up there, I assume. And then, he won't even be able to come here to get his stuff. You'll have to have an officer present to do that.
Okay.
That's the best route. So if you go to the municipal court, you tell them you want to file for protection order, they'll give you a packet to fill out.
Okay.
And then I would ask for like the emergency one, since there's start of violence, you probably will get that, and that'll be enacted immediately.
Okay.
And then you'll have a court date in the future to solidify that.
Okay.
All right. Do you have an ID on you,
The driver's license.
or can you give me your information, or you want to get it? Unless you're taking Jason.
I heard him out there banging on their guys. He's got issues, I'm telling you.
What's his name?
Zachary.
He looked familiar, but I
He's been in so much trouble.
I don't recognize the name, but I recognize his face.
Do you have any drug usage?
Oh yeah, yeah.
So there's a
That's what
history
started all
of
this.
that.
He's been in prison. He's been all kinds of places, and he'll get clean for a little bit, and then goes right back.
So does he act like this when he's using drugs, and
Yes.
then he don't act like this at all when he's not? Or-
He's not as bad.
Okay.
When he's been doing something, you can really tell because he acts psycho. He's like rambling and stuff, and
About
like,
the government?
everything.
What's he normally use when he does?
I don't really know. I don't know.
Kid notes and
Thank
everything.
you,
I know
bye.
he used to do the hard stuff because my sisters had to use what's it called, the
Narcan.
3 times on him.
Yeah.
So he used to do the hard stuff. Now I think it's just marijuana and stuff. But I don't know for sure.
Top on, get that.
That seemed more like a stimulant, but
He goes up there and buys those
Just like
vape
them.
things.
what is it?
Stick thing.
Oh, like the vape pen.
Yeah.
But he's got a long history of drug use, and
Okay.
he'll say stuff like he's the most important man in the world, and I'm like, why? Well, because I got the Star of David. He needs
What's-
help. He really
Did
does.
you have a prong in him?
I don't know if there's one that stuck in or not. I know there's one with my
Let's go
wires.
assess him and make sure he's not injured.
We should be good with you guys, okay? The incident sounded like it happened out in the county. They just knew that he had a residence here that was staying at and wanted us to make contact with him.
Yeah.
Right.
Yes, they was at the VA
Yeah.
when he started harassing them and stuff.
Okay. But, you know, if we have any other questions, we'll come and knock and talk to you a little bit
He
more.
lives here, right?
Yeah.
So that's going to be your best bet for the protection work, because otherwise it's like 60 to 90 days for an eviction process.
That's what I was afraid of. But if we do emergency protection order,
Yep.
he can't come back.
Correct. And then start the eviction notice, so that way, during that time period, he can be evicted from here. I don't know if that goes hand in hand or not, but
He don't have your truck keys, does he?
that's something to ask the victim's advocate. I'm not sure if the eviction goes hand in hand.
We did have a set of keys on him. There was a set of keys on him.
He doesn't. We need those.
I can't necessarily take his keys from him.
It's to the garage.
I understand that, but he's
He
also a
doesn't
resident
have no
here.
keys.
If you could work something out with the jail, I don't think I could take his property from him because he is a resident here.
You might have my birthday.
He does.
Yeah. Regardless if he gets OR'd or whatever from the jail and he comes back here, you know, our hands are kind of tied. Because he's, you know, until Monday morning, like you were saying.
Will he be in there till Monday?
With his charges, I don't believe he'll have a bond until his court appearance. That being said, I have seen people get released. I highly doubt he will. I can't guarantee anything when it comes to the court.
Was he fighting you guys?
Roughly, yeah.
So you can't bet they're holding for that too, right? Resisting?
Yeah, but that's nothing. They'll
Why do they do
they'll be
this?
released the next day on their own recognizance for that. So,
Cops can get the shit beat
Yeah.
out, they don't care.
Yeah, that was on him. But
Oh.
it sounds like.
Oh, yep, that's them.
like I said, I don't. If these are
Did
his
you
property,
take them from him or was they laying out there?
No, that was on him in his left pocket before
That's
I
not
heard.
his property.
well, I mean, what's the car go to?
A truck that's in the garage and the garage key.
Whose truck is it?
My dad's.
Is it in your name?
Yep. There's nothing in his name. Like I said, he was in court. He didn't have nowhere to go. He come down here. He told Dad to be
Truck's
for
in his
2
name.
weeks.
It's just truck keys in the garage. Okay.
I know it's in his
And if he
name.
lives here, we're leaving out his residence. So
49
I'll take the heat on it from you then. Check him out. All right. Well, we're gonna get him over there and get him assessed.
That's his
and everything,
too.
so.
All that stuff that was on him that was his.
There's no way we'll know when he gets out. Can anyone call
Yeah, we're gonna
us?
give you a. Well, the county should. Well, you guys aren't the victim. Well, the victim of the crime. What's her name?
Jennifer.
Keep in touch with her because the court has to notify her when he gets out.
Okay.
So she'll be able to tell you.
All right. That's her son.
And you could always look it up online.
Okay.
The Ross County inmate list should be on there. So.
Okay.
Her call.
He should be in jail at least until Monday for his initial appearance. So first thing in the morning, hopefully it'll be enacted and they can serve him before he's released. That way he can't come back here. If he comes back here, regardless either way, call. Because if you got the protection order, because then he could be served when we contact him if he hasn't been already.
Okay.
All right,
Yep.
we'll get him up there.
All right. Thank you.
You're welcome. I didn't mean you did that. Okay, just make sure.
This is a case study in use of force doctrine under Graham versus Connor, examined through publicly available body cam footage. This is not a simple domestic call. This is a constitutional stress test, and I've seen a lot of these, but this one hits different because every single actor in this scene made a choice that had real legal weight. Let's start with the arrest authority. In Ohio, a protective order violation under Ohio Revised Code Section 29:19.27 is a first-degree misdemeanor, escalating to a fifth-degree felony on a second violation. Officers had probable cause the moment dispatch confirmed an active order and documented contact through the father's phone. That's enough. No warrant required. Warrantless arrest is fully authorized under Ohio law. Now, the Taser. Graham versus Connor, 490 United States, 386, 1989. Sets the standard. 3 factors: severity of the offense, whether the subject posed an immediate threat, and whether he was actively resisting. Here, a documented threat violation, a history of violence, active flight, and prior resistance. But here's the human thinking counter-argument. He was running away. Tennessee versus Garner limits force against fleeing suspects when no immediate threat to others exists. And that's the tension. The Taser was deployed at approximately 20 feet, near the outer range of the close-range cartridge. One probe may not have connected. If the force was applied but failed to achieve its purpose, the totality of circumstances analysis gets complicated fast. A plaintiff's attorney would frame this as disproportionate force against a non-armed, fleeing misdemeanant. That argument has legs, and officers need to know that. On Miranda, the subject demanded his rights read the moment cuffs went on. The officer said, "I'm not asking you questions. That is legally precise." Miranda versus Arizona, 384, United States, 436, 66. Only triggers at custodial interrogation. Arrest alone does not activate that clock. The subject's demand reflected a real constitutional instinct, just aimed at the wrong moment. His knowledge was incomplete, not wrong. The subject also alleged he was punched in the face during the takedown. Officers did a visual check. That's not enough. Under Ohio Revised Code Section 2933.81, use of force incidents involving injury allegations, even disputed ones, require documented on-scene assessment and a written use of force report. A jail nurse referral was made, correct, but the absence of contemporaneous notation creates a liability gap that defense attorneys exploit routinely. Now the keys. The subject had the father's truck keys and garage key on him at arrest. Officers declined to seize them, citing co-residency. That call was legally correct. Without a court order, officers cannot remove personal property from a co-resident, even one under arrest, even when the property belongs to someone else. The Fourth Amendment protects possession, not just ownership. Frustrating? Yes. Wrong? No. The officer's guidance to the family was, in my view, the strongest part of this entire call. He correctly explained that standard eviction under Ohio law takes 60 to 90 days. An emergency protective order, filed Monday morning at the municipal courthouse, takes effect immediately upon issuance. If served before release, the subject cannot return to the residence at all. That's the fastest legal barrier available, and the officer knew it cold. Officer assessment. The responding officers managed a volatile, multi-party scene with consistency and legal accuracy. The guidance on protective orders, eviction timelines, and inmate notification was precise and genuinely helpful. The decision not to seize the keys was legally correct even under pressure. The one area that merits scrutiny is the Taser deployment at distance and the handling of the use of force allegation. A verbal check is not documentation. That gap is where lawsuits begin. Subject assessment. The subject exercised his constitutional knowledge, imperfectly but visibly, demanding Miranda rights at arrest and invoking his right to medical attention. His flight was legally relevant to the force analysis, but not independently criminal. His core problem was behavioral, not intellectual. Every escalation on this call, the threats, the phone use, the flight, was a choice that compounded his legal exposure. Drug history flagged by family adds context, not excuse.
Bud, you ain't arresting me, bud. No, you're not.
He's 21. He's running.
Keep me, bro. Oh,
Get over on his stomach.
keep me, bro.
Get over on his stomach.
I'm tired. What the is this for? What the is this for, man? punch me in my face for real, dude?
Okay.
You guys are going to be in trouble for this.
Yeah, that's what you do when you hit somebody else in the face.
I didn't hit nobody.
Yeah, yeah. Sure.
Who did I hit?
Hit me right in the face.
Bob, I was trying. Oh, okay. I'm trying to run from you guys because I'm scared to death of you.
Hold on. We're going to help you up, okay? Go here on your side. Knees up to your
What
chest.
the is this about anyway?
All right, on three.
Well, if we
Ready?
were stuck around, we would have
1,
climbed it to
2,
you.
3.
Get the,
We got 21 headquarters.
What's the charge?
That's pretty county. Technically, whatever.
Oh, isn't it? You guys are all going to jail for this. Read me my Miranda rights.
I'm not asking questions.
Huh?
I'm not asking you
Are
questions.
you arresting me?
Yep.
Then you have to read them to me. Code of conduct.
I'm not asking you questions.
Code of conduct. Are you
Have a
arresting me? You arresting me?
You're under arrest.
So you read me my
Have a
Miranda.
seat.
Well, the count.
Are you injured at all, bud?
Yeah.
Where are you injured?
Punch in the face.
I don't see any injury. Why the jail nurse check it out?
Okay, well,
You got-
can you read me my Miranda?
Can you sit forward?
Can you read me my Miranda?
Can you turn that way? I'm looking at your back.
So, can you read me my Miranda
We'll just
right?
look at him in the jail.
Can you read me my Miranda right?
You have the right to remain silent. There you go. Just make sure when you're down there that you look for the probe.
I have one.
And then probably have the jail nurse at least assess him so we'd have him medical attention.
I keep it, and you have to wrap that in evidence.
Yeah, you got to wrap your stuff in evidence. Your probe. You got it still?
Yeah, I wrapped it up.
Both of them there?
There's one.
You got both cords?
Yeah.
You'll probably never find the dart. I'll look around for you. You should have the cartridge still in it. But the dart probably, if you missed, it probably flung right off the... Yeah.
I thought you might have hit him. I seen him stacked up, so I was like, that's probably not going to take him anyway.
I couldn't tell if he was shocked yet or not. I just saw him still running. Yeah, I don't know.
No, I had the widespread on it
Oh, did you change it?
for distance. Yeah.
The widespread's for
Or not
close
the-
up. For
I had the
you
close.
had the close one?
The close, yeah.
Oh, the close one should have hit him from this far. That's about the limit though. This is what, 20 something feet? Probably more than that.
It's probably.
He wasn't layered up.
That's all right. You got enough. I'm not gonna have a search party up. Some wires. I see it. Yeah, it's empty.
I didn't know what way he was going to run, or I'd been more ready. I thought he would have went
Yeah.
off the fence and kept going that way. I would have never thought he would have turned back this way.
He didn't want to jump. Path of least resistance.
I would have had my taser already up.
That's why.
Ah.
It said he fights and pops around mouth.
He was a lot bigger than I expected him to be.
Has a history of aggression for doctrine.
Yeah, I'm fine with it.
Lesson 1. If someone in your household is violating a protective order using your property, your phone, your car, your home, you are not powerless. Ohio law allows you to file an emergency protective order as a household member affected by the conduct. Do not wait for the next arrest. File Monday morning. Get it served before he walks out of that jail. That window between arrest and release is your single best opportunity, and most families don't know it exists. Lesson 2. If you are ever placed under arrest, do not demand Miranda rights at handcuffing. Stay silent instead. You do not have to speak at all, and silence cannot be used against you the same way a statement can. Miranda protects you during interrogation. Your right to remain silent protects you from the moment of contact. Those are two different tools, and confusing them is exactly what gets people to talk themselves into deeper charges. Lesson 3. If an officer uses force on you, and you believe it was excessive, document everything the moment you are medically cleared. Photograph injuries. Request the incident report number. File a complaint with the agency's Internal Affairs Unit within the required window. In Ohio, civil rights claims under 42 United States Code Section 1983 have a 2-year statute of limitations. That clock starts the day of the incident. Don't lose it by waiting. Resources for domestic violence support and Ohio protective order procedures are linked in the description. The legal system doesn't always move as fast as the families caught inside it need it to. But the tools exist, and knowing how to use them before the next crisis is the only real edge you have. The Constitution does not enforce itself. That's what these cases are for. Thanks for watching.